Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This past week in the Idaho versus Kohberger case has been a very busy one for everyone involved, for the defense, for the state, for Judge Hippler, for various witnesses. We know that there were a series of hearings that occurred on January 23rd and 24th that were enormously important to both sides. But also this past week saw the reemergence of the Media Coalition, the group that, when this matter was back in Latah County, attempted to get the non-dissemination order set aside. They actually went to the Idaho Supreme Court, where the Idaho Supreme Court indicated that they were supposed to go to the lower tribunal first, not file paperwork with the Supreme Court first to try to get that non-dissemination order set aside. But they also, the Idaho Supreme Court, made a ruling that the Media Coalition had standing. Now, you've heard this term thrown about this past week, including when Judge Hippler asked the defense, words to the effect, does your client have standing to challenge this DNA, IgG evidence? In any event, this past week saw the Media Coalition file two sets of papers. First, on January 21st, seeking to be heard before the court's hearing that was being held that day to determine behind closed doors in a session where just the parties, Mr. Kohberger was present, whether or not the hearings on the 23rd should be open to the public, should be closed to the public, and what portion. Since she's the same lead counsel who represented them back in 2023, asked to be heard as interested parties either before the hearing or during the hearing, and raised the First Amendment as the reason why. Again, now they had already been deemed as interested parties because they are the press under the First Amendment, which guarantees freedom of the press. There was a second set of documents that are dated January 22nd, 2025. It was not on the docket until yesterday, which was the 24th, although we did a podcast on the Indie Zone where we indicated we saw these two documents on the case summary page maintained by the clerk of court. We knew they were public. They appeared to be relative to the Media Coalition. We now have them, and you can go on the public docket to review them for yourself. The first that I wanted to call to your attention is a notice of hearing. This is filed January 22nd, 2025 at 11:12 a.m. that day. It says here that notice is given that the above-styled case, and whenever you see that term, the above-styled case, that means State of Idaho versus Brian C. Kohberger with the governing case number, is set for hearing on a renewed motion to be heard as interested parties on Wednesday, January 22nd, 2025 at 3 p.m. Judge Stephen Hippler presiding at the Ada County Courthouse. Hearing to be held remotely by WebEx, clerk to send link prior to the hearing, signed by the deputy clerk. And we see here the certificate of service going to William Thompson, Jeffrey D. Nye for the state, Ann Taylor, Eliza G. Mazoff for the defense, Jay Logston for the defense, and then Wendy J. Olson for the Media Coalition. So if you were around the afternoon of the 22nd, you might have gotten notice that there was this hearing that seemed to pop up out of nowhere on the Ada County Court's official YouTube channel. And some people, including myself, thought maybe this was a test that the administration was performing to ensure that the next 2 days of hearings, which would be part of them, at least broadcast to the public, that everything was in working order, but there really was a hearing. And at that time, Wendy Olson, on behalf of the Media Coalition, got up and she spoke and gave her pitch as to why the hearings on the 23rd and 24th should be completely open to the public. Judge Hippler rendered an oral proclamation from the bench, an oral ruling, that he made findings of fact on the record, that there recognizing the First Amendment. But however, there was another overriding issue that prevailed here, and that was ensuring that there would be an opportunity to seat a fair and unbiased jury. And you can learn a little bit more about where his reasoning was, the legal authority cited, including U.S. Supreme Court jurisprudence precedent. If you look at this document, this had to do with his denial of the defense's motion to have that hearing on their motion to suppress IGG made public, and also to have all of the filings related to the motion, the response, the reply, and all of the memorandums of law and supporting materials made public. That is called the briefings. The court denied it. Read that ruling and you'll get what the court found. What I found very interesting, however, with respect to the matter of this potential Franks hearing that we know the defense is seeking, I did an episode here on the YouTube channel just yesterday, some clues that Judge Hippler may possibly be leaning toward a yes, or at least granting the hearing. Not that he's granting the motion, but potentially the hearing. So if you haven't had an opportunity to do so, please listen to that. But I wanted to read directly from the second filing that you can read. It's called the renewed motion to be heard as interested parties. This is what the court was referencing in the notice of hearing. With respect to this filing, if we go to page number 2, it says here, on January 15th, 2024, this court issued a notice of hearing, an order regarding January 21st hearing. In that order, the court set a closed, sealed hearing for 10 a.m. on January 21st to hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA, and 2, consider what portions, if any, and under what circumstances would the various motions set to be heard on January 23rd and 24th be open to the public. While the court's order setting the January 21st hearing unambiguously closed the hearing to the public and thus the press, it did not make any specific findings to the probability that the defendant's right to a fair trial would be prejudiced, nor was any member of the public or press provided an opportunity to raise objections. And then they go into when they filed their motion and what the court ruled. That the court ruled it was untimely, that it was filed just shortly before the 10 a.m. hearing. Well, on page 3, you'll see here, also following the closed January 21st hearing, the court entered an order governing the proceedings on January 23rd and 24th, 2025, in which the court ordered the proceedings closed at the outset while it takes up testimony. Testimony is the oral statements on the stand of witnesses. You saw a little bit of it during the open sessions that was open to the public of the hearings on the 23rd and 24th, where witnesses, specifically 2 witnesses from the Moscow Police Department, got up on the stand. So that's what testimony means. Related to the defendant's motion to suppress genetic information and the defendant's motion for a Franks hearing related to the IgG investigation, order governing procedures for the January 23rd and 24th hearing at 1. So she's citing to the record. This is what the court talks about when you hear him stating to the attorneys, you need to cite to the record. You need to point me to the record exactly where this evidence is located or where you're wanting the court to look. A Franks hearing, Ms. Olson continues on behalf of the Media Coalition, is an evidentiary hearing. That's where evidence is taken, where people give testimony. And that's exactly what happened here. That allows defendants to challenge the truthfulness of the statements made by a law enforcement officer in an affidavit, typically in support of a request for the court to issue a search warrant. And then she cites to State versus Fisher. This is an Idaho Supreme Court case from 2004. At a Franks hearing, the defendant bears the burden of proving that any false statements were deliberate or reckless, citing again to State v. Fisher. The court further ordered that the courtroom would be closed, but the remainder of the proceedings would be live streamed, subject to the court's determination at any time to close the hearing. She cites again to the order governing proceedings. So this, number one, led to the hearing that you may have saw live or heard about or seen on replay that occurred in the afternoon of the 22nd pursuant to this notice of hearing. But here we see some argument and pointing out that there was indeed evidence that was taken in support of Mr. Kohberger's Franks hearing that may lean the court toward granting the hearing, but also provide the media coalition with possible further grounds to file something, again, in the Idaho Supreme Court, this time pointing out that they did go. They went to Judge Hippler first, and although they were provided with an opportunity to be heard at that hearing on the 22nd, what they ultimately wanted, which was the entire proceeding to be open to the public, was denied. So time will tell if the media coalition does that, and will tell if Judge Stephen J. Hippler does in fact grant this motion for a Franks hearing. Now, just because Judge Hippler, even if Judge Hippler grants it, Mr. Kohberger has an extremely high burden of proof to get this relief. And I do recommend, if you have not already, to watch some of the prior episodes of the Indie Zone podcast and here on YouTube, where we went through what that burden that the defendant must prove to be successful here. This will now conclude this episode of the Indie Zone. Thank you, as always, for joining us here today.